Oh yeah, I'm way up there.
You're tall today?
I'm so tall.
Damn.
Hey, I'm Matt Mulholland. That's Remington Huggins. This is the Listen to This Bull live show, the show where you get to ask us questions live, and we'll answer them to the best of our ability. And hang on, we're about to get more pretty. Did we? We didn't. That
We just
didn't
got
do
focused. We look good.
She touched the camera. Did it improve?
The hat knows what she's doing.
I feel like I got a little bit lighter.
A little
when
5
she
pounds.
Did that. Like that 10 pounds that the camera adds. It took off a little bit more. The second she touched that button, it's like an instant weight loss button.
I push it again. Well, why not?
No, you guys are fine.
Guys, today we have a special guest that's coming on. He is a licensed attorney in the state of Florida, in Georgia. He might be licensed in other states as well. His name is Dale Shelton. He owns his own law firm, Shelton Law, PLLC. He has multiple offices in Florida, including Tallahassee, Jacksonville, and I think Fort Myers or Cape Coral. But he's here to talk about some issues, or I don't know if they're issues, but a bill that the Senate or is it the House or is it the Senate?
It's a Senate.
It's the Senate bill.
Senate Bill 76 out of Florida. So this is a Florida show today.
And again, he practices in other states too, so we can get a little squirrely.
The fun part about anything that happens in Florida is it eventually happens everywhere else.
That's true.
Eventually, we're going to have snowbirds everywhere.
Yeah, that's true. What is kind of crazy is that some of this bill, to my eyes, is coming from Georgia, and we'll kind of get into the weeds with it. Yeah, they're kind of trying to follow a little bit of what Georgia does and other states, not just Georgia. But we won't get into the weeds until a little later. But Dale Shelton's here. Like I said, he knows what he is doing. He owns his own law firm and runs it, and he's got a lot of knowledge.
Yeah, I think that he'll be just fine. There he is.
He is. Dale,
doing, guys?
Doing good.
Doing good. How are you doing,
not official. I don't have a fancy headset and stuff. Should I put my Beats on even though I'm not using them? I look cooler.
Yeah, there you go.
Instant look. It's instant.
Yeah.
Automatically, you look so much cooler. I'm trying to read what's on your whiteboard back there. I think that there's some weird math.
Yeah, some really secretive stuff that I'm just going to lean my head like this. I can't give away the trade secrets, you know.
Probably some data on there that you're not supposed to share with anyone. I think this is recorded.
Yeah.
You better make sure.
He's like double checking. He's like, nah, we're good. We're good.
No, mainly my own personal stuff for how I'm going to lay out all my different web of trust and LLCs for asset protection purposes. That's the main thing. And then, if you want a little,
that's written there. Is that a lunch menu too?
No, I got a little Proverbs quote if you want it. The plans of the diligent lead to profit as surely as haste leads to poverty. Proverbs 21:5.
Haste. I thought it was ham.
You thought it was ham. No, it's haste, Matt. It's haste.
Gotcha.
Not everybody puts their menu on the whiteboard, you know.
Yeah. What are you saying? So you've got a House bill that you're dealing with out there in Florida right now, or a Senate bill. We said it again.
Yeah, I mean it's in the mix right now, and I think as Remington was alluding to, it has a lot of fingerprints from what we see in Georgia. Everything. Let's start here. Across the nation, Florida, if you're a homeowner and you have damage to your property and your insurance company doesn't want to pay you, there's no better state to live in than Florida. Quite ironically, I will also say, if you live in Georgia, right across the border, there's almost no worse state to live in, right? And Remington, I think, can speak to that. I'm licensed in Georgia as well. And one of the key things there that tends to impact it is the attorney's fee statute. And that's one of the things that the Senate bill goes into. So just to excuse me?
I've heard about this. I was actually hoping to do a show on it. Hey, how about that? Here we are.
So to juxtapose the two, I mean, in Georgia, no attorney's fee statute whatsoever. What this really means at the end of the day, yes, there's attorneys that do frivolous stuff and everything else. I'm not talking about the bad apples in the group that abuse everything. Legitimately, why you have an attorney fee statute, it's for consumer protection. You want to give the consumer access to the courts, especially when there's a disparity between a large national insurance company with all their resources and John and Jane Smith who saved their whole life to own at the age of 60 their 3-bedroom, 2-bath house outright. Storm comes, damages their home. Insurance company comes out, either wrongfully denies or wrongfully underpays. Now they're left in the spot of, I don't have enough money to do the repairs to my home that I need to. In Georgia, we're having a very different conversation with them. You should go ahead and plan on 1 year to 2 years. We'll probably have to settle your claim somewhere at 75 cents on the dollar. And then, because your legislature hasn't imposed any law to where we can recover attorney's fees, we're also going to have to apply our fee to the already reduced compromise settlement. Florida is a much different conversation. Under the Florida law as it currently exists, and right now, there's actually a difference in Florida right now between representing what I call a direct sign case, where you represent the insured directly, or whether you're representing an assignee, being an AOB contractor. I have clients that are AOB contractors as well.
What's the mix there? How much direct versus AOB?
My own personal experience?
Well, yeah.
Roughly,
somebody else's.
Roughly 50-50. I didn't know if you're referring to specifically the attorney's fees, what the mix is. But yeah, no, about 50-50. I was kind of bored.
The fees up too? On the same case? Do you split the fees up? Is that what you were just saying? You might charge the direct and the AOB a different amount for the same case?
Yeah, the current state of the law in Florida is that the fee statute applies differently after the July 19 AOB law that came into existence in Florida. One of the things that did is, and right now as it sits, and this is what Senate Bill 76 is looking to change as it relates to the individual homeowner, if they were the direct client. The Florida AOB law came in and said, hey, if you're representing an AOB contractor and you file suit, you can only recover attorney's fees if you recover at least 50% of the amount in dispute. If you recover 25.1 to 9.9%, however exactly that. Anyway, from that gap in the middle, it's a wash. And then if you actually recover less than 25% of the disputed amount, it allows the insurance company to go ahead and acquire the right to obtain attorney's fees from the underlying contractor. Now, this was put into place because there were a lot of contractors that were abusing the assignment of benefits. Yeah, the biggest egregious examples we saw on the water mitigation side of things. Yes, I personally have seen estimates come across my desk where I didn't represent on it because I thought it was unreasonable. 3 days of a dry out, some fans in there, $50,000 invoice for mediation, for remediation rather. And it's just, that was the use and abuse that I disagree with. I was actually one of the few attorneys on the plaintiff side that I encountered that I was actually in favor of some kind of regulation coming in because I realized just how much the assignment of benefit contractors that were abusing the situation, not doing it legitimately, was actually hurting everything. Because the assignment of benefits is a really good tool for a homeowner. One thing I've come to learn in doing this area of law, for whatever reason, I'm not here to get into the politics or whatever of it, but most homeowners don't have money in hand to cover their deductible. For whatever reason, just life is hard, a lot of bills to pay, whatever.
Especially if it's a hurricane percentage. Just want to throw that out there.
So, and that's just their deductible, much less be able to come out of pocket for the additional expense. What the assignment of benefits does is they're able to get work started immediately by assigning over their rights and benefits. They still have the obligation to pay their deductible, which they'll be able to do upon resolution of the claim, which gives them the time to save, or there's various lenders out there that'll lend for deductibles, personal loans, and things like that. So it's a very useful tool. But the key thing is going back to the fee side of things, and even with that new AOB law being put out there, the individual homeowner still didn't have any risk of owing fees for the other side. And that's still how it exists under Senate Bill 76. It's not proposing to have the homeowner on the hook for the insurance company's fees if you don't hit a certain percentage. But what it is doing is wanting to essentially make a rebuttable presumption in favor of the fact that a fee determination is sufficient upon the, quote, lodestar method. Now, in layman's terms, what that really means is reasonable amount of time spent on the case by the attorney multiplied by reasonable hourly rate of that attorney, which on its face just seems reasonable, and it's not completely unreasonable. It's certainly better than the situation in Georgia. However, this is effectively what's happening. prior to Senate Bill 76, the courts are actually allowed to take into consideration what's called a multiplier based upon contingency risk factors. Now,
so you're saying like a contingency fee that usually attorneys do with their client
so
that they execute.
I think it's no secret out there. The overwhelming majority of attorneys that are on the plaintiff's side representing homeowners in this field, we're on a 100% pure contingency fee basis. I don't charge anyone any money up front. I'm only recovering if I actually recover for them. And I actually do it a little different than most is I'm contingency on my cost as well. I advance all the cost and the homeowner doesn't even owe me for reimbursement of those if we lose. I literally have skin in the game with them. So the problem though is with Senate Bill 76, taking out that contingency risk factor, but because it allows the court to add what they call a multiplier. So essentially you would do that reasonable number of hours times reasonable hourly rate. Then if the court saw that there was essentially a risk that was taken on by the attorney, then the court can add a multiplier, say a 1.5, 2.0 multiplier, which essentially it does what the title says. It just multiplies that attorney's fees amount by hours and hourly rate and multiplies it by that. Well, it's really easy for the insurance company to put on a big front of how unreasonable is that? Why do they get a multiplier? Well, I think it's important to hear objectively why on this side of it, that matters, because this is how the economics is going to work.
We don't have
multipliers. An attorney.
No, I've never heard of it.
No, we don't.
Who
I was being sarcastic.
Who comes up with the multiplier? Is there like a schedule?
The easiest answer is it's up to the judge. Now, there's case law and everything where there's a list of host of factors. It's a multi-factor test. At the end of all of these things, it says plus anything else the judge deems relevant. So, I mean, there's some case law that gets you in a relative ballpark, but all in all, it's judicial discretion, which is honestly probably a good place for it to be, in theory anyway, assuming that it's getting carried out judicially appropriately, which I have no reason to suspect that it's not. But what's going to happen is if you take away the ability to obtain the contingency risk multiplier, then you're going to necessarily cut down on the amount of available representation for homeowners for a couple reasons. First is the whole reason we're willing to take these on with no guarantees at all, expend our own money, and we might not recover any of it and actually be negative on the case is the reward. It's a risk-reward business analysis is all it is. And the underlying reason for having an attorney fee statute, mind you, is public policy. We want the consumer to have access to good legal counsel when there's a disparity between the power of one party and the lack of power of the other in resources. And that's exactly what we have in the general residential homeowner versus the really big mammoth insurance company, right? So
the big bad insurance company acts poorly. They get their hands slapped by having to pay your attorney's fees. That makes sense.
But here's what's going to happen. If you take away the multiplier consideration, attorneys, at least business owner attorneys, seem to make really sound decisions like this. And what they're going to realize is the risk reward's not here anymore, right? I'm going to take on something complex with no guarantee. But then if I win, the way that I get my fees paid is based upon just an hourly equation, right? So if you flip that analysis and think about it this way, if I signed up with a homeowner on an hourly basis, I would want to do that on the front end because I know I'm not going to make as much money overall, but it's guaranteed. So you're making less, but you don't have the risk, right? But if you keep it on the contingent, because these homeowners they don't have the money to sign up to a guaranteed hourly rate contract. The insurance companies know this, right? So if the only way then the attorneys assign people up, it's going to be, okay, now I got to do hourly rate on a contingency fee basis. Well, I might just go shift to another area of law. It might not make as much sense from a business perspective. So I see an ultimate negative impact in terms of representation being available for clients. And likely what's going to happen is it's actually going to negatively impact the people that need it the most. Smaller claims. Smaller claims generally, on average, a lower net worth individual because they don't own because our claims are essentially a percentage of the value of the home most of the time because it's in relation to the size and quality and materials on the home. So there's a great correlation there. And if you run it that way, you're going to have a lot of low income, lower socioeconomic status people that need the help the most that are going to start running into problems of actually finding available attorneys. I mean, just speaking straight up on here in Georgia. I mean, I've talked with Remington about this. He has a big heart, so his threshold's different. But I just, literally just talking from a business perspective, we physically will lose money if I take on a $30,000 shingle claim in the state of Georgia that gets run through the gamut for 2 years. Like when you factor out hourly rate for the fees recovered and everything else, essentially it equates to basically working for less than minimum wage, hourly wise, right? So a lot of people don't have representation on those smaller claims. Well, the insurance companies are aware of that. So who do we abuse more? Smaller claims. They can't get representation. And it creates this cycle. So that's one thing that I'd really be aware of. And I think it's important to be talked about objectively. I don't think attorneys should be getting huge home runs on fees either. I mean, our firm doesn't work that way. And here's something important. There's a lot of firms, not a lot. There are certain firms out there that I know of that their business model is more to get a small number of claims, sit on them, run up the hourlies, so that way they can have a $30,000 roof claim in 2 years turn into a $900,000 fee bill in a court hearing. That happens. That has happened. I know about that one specifically.
Sure.
I don't agree with that. So something needs to be done. But I think kind of like the AOB law when they put the $3,000 cap on mitigation for assignments, I agreed that for not mitigation, remediation efforts, the $3,000 cap, I agreed that a cap needed to be put on it. 3,000 is illusory. They might as well have put 0. You can't get anyone to come commit to do legitimate cold water remediation work for $3,000. I think 10 to 15 is more than reasonable for a cap. Same problem here. I think the direction it's going, if I'm speaking objectively, now there might be plaintiffs that are going to yell at me for this, but no, I'm right. Objectively, yeah, we could have something to make some of these fee situations more reasonable. I don't think a $30,000 roof claim that is intentionally being drug out. It's one thing if the insurance company is wrongfully fighting. It's another thing if you're sitting on it, not wanting to settle because that's your whole business model. That's making the homeowners lose, the consumers lose, everyone lose, right? That's
Dale, thinking just touching base on the bill itself, I feel as if this bill that they're trying to push or that they've drafted, right, is going to push plaintiffs' attorneys more towards sitting on claims and churn as many hours as possible, rather than a contingency where if we get a file and we can settle this in 2 weeks, we're going to settle it in 2 weeks, rather than, maybe play, I'm sorry to say this, but the defense counsel game, right? Kicking the can down the road.
I mean, that makes sense. Right now, you've got a position where you've got the Lone Star, but you have a multiplier, and you're taking the multiplier away, basically. So it's an hourly basis, one way or the other. The situation that you have in the current hourly basis with the multiplier, if people are sitting on it, the other hourly basis doesn't have the multiplier, but the longer it goes on, the more hours you can accrue, the more money you'll make. It doesn't solve that problem. It probably makes it a little bit worse.
It will solve the problem in terms of probably lower on average fee amounts the insurance company has to pay, but it's going to, good point, Rem. My moral compass is such, I'm not sitting here tooting my own horn, but we just don't do shit like that. When we get a claim, we run every claim the exact same way. We file suit and we're pushing it to trial as hard as possible and as fast as possible with no unneeded delay. And if the insurance company wants to settle along the way, great, we'll settle. Otherwise, we're going to trial. That's how we do every single claim. So I didn't really think about what you were saying as much, Rem, but yeah, I think that's an excellent point. That's going to, if you look at the math of it, it's a simple, people are incentive based, right? There's entire economic theory centered around incentives. Right? That's generally what economic theory is centered on. I majored in economics. That's what they talk about. So if you put the carrot and dangle it out there, you make more money if you make this take longer. Well, what's likely going to happen? It's going to take longer.
Yeah.
Right.
And who's actually getting harmed there? Not the insurance company, because they're getting to earn interest all the way through, not having to pay this money out. And the longer these things go, a subsequent storm could hit. Someone could sell the property. There's a lot of various ways that the claims can just fall away. And they drop a book that I have nothing to do with, but I recommend it because I love it. Delay, Deny, Defend. It's a great book. It talks about basically the shift in the mid to early 90s where Allstate was the first one to do it, brought in a consulting company. Consulting company went straight to the claims handling department and basically said, hey, instead of going out trying to find coverage, let's go out and try to find how it's excluded. And the author of the book had a great quote. He said, Allstate went from having you in good hands to putting on boxing gloves.
Yeah, that was a different book, From Good Hands to Boxing Gloves. There's another book that's called From Good Hands to Boxing Gloves.
Really? Well,
Yeah.
The author might have stole that quote from somewhere then, but yeah.
Could be the same author. I don't actually know. It's entirely possible.
Fair enough.
There's a line in this bill that says, talking about the Lone Star fee being sufficient and reasonable, such presumption may be rebutted only in a rare and exceptional circumstance with evidence that competent counsel could not be retained in a reasonable manner.
That's exactly what Dale just said.
Could not be retained.
Yeah. So basically you're having to find that might come into play with some of the panhandle work that's going on. So with one of my offices being in Tallahassee, I worked a lot of Hurricane Michael, and the populace there, because there's not as many storms that have hit, is just generally not as educated on how the insurance stuff works. Once you go into South Florida, I mean, the consumer base understands how the insurance game works because there's enough storms and everything. So from what I've seen, in my own personal opinion, not talking about any specific insurance company, so don't bring me with slander or libel, the adjustment gets worse once you get into the panhandle. It was some of the most egregious adjusting I've seen. I mean, I showed up to one claim. If you looked at the estimate, you would have thought that it needed a new roof and a little bit of drywall. I pulled up, the freaking house was like this. You could see the backyard when you opened the front door because everything was messed up. The engineer showed up on the reinspect. They got out of the truck. The engineer for the insurance company was like, why are we here? I'm like, you tell me, right? Their adjuster showed up. Same thing. Why are we here? Like, you tell me. And then within a couple of weeks, we had policy limits paid, right? Because it was such egregious. But the point being is it never should have been that bad. But if you get into these rural areas out there, well, Chattahoochee, Florida, a client that turned into a personal friend of mine. I mean, that's where he's located. And I guess unless you're trying to go to Tallahassee, that doesn't necessarily have a bunch of firms that specialize in this, you're kind of left. Really what we're talking about is people that can't find competent counsel. The insurance company knows that that's going to be a very hard standard to satisfy in the state of Florida. So it's basically illusory because they're going to argue, Google Florida property insurance attorneys. Look at how many pop up. You couldn't pick any of those. None of them wanted your case, right? That's where it's going to go.
It only calls them competent counsel, and it says in a reasonable manner. So how do you determine what the reasonable manner would be? Well, I had to look them up online. I couldn't call them because my cell phone wasn't working. That's completely unreasonable. I shouldn't have to do that.
Yeah, that's probably not going to fly, right? But
somebody's going to have to come up with something, though. I got a question for you from Michael Turner. That's your guy, isn't it?
Yeah.
How has Florida's new AOB law affected your firm, Dale?
So he's asking if you've gotten less AOB clients because of that new AOB law. That's what I'm getting from the question.
So first, Michael, thank you for the question. But dude, we work together, man. This is kind of like you don't send a question into the thing when we work together. We got to get random people.
Are you saying this is a softball question? Did you set him up to ask this?
He's not.
That's crap.
I just like screwing with Michael. It's more fun that way.
He knows Michael.
No, so how has it affected the firm? Well, the biggest thing is that so compliance with the law on the front end is one of the most daunting things. So the original versions and talks about the new AOB law had the insurance company trying to completely eliminate assignment of benefits in the construction realm being used in the state of Florida due to constitutional challenges. And then you can't segment out a certain realm of services since it's construction, because AOBs are used all the time when you go to the doctor. It's an insurance policy. When you go pay your copay and you don't have to worry about anything else, what do you think is going on in the background? You sign an assignment of benefits, they're going and collecting their money or suing
and people don't realize that at all. But that's 100% what's going on.
Exactly. And that's why when I heard the talk that they were going to completely eliminate AOBs in the state of Florida, I knew that wasn't going to work because the insurance company's lobbyists were going to be running directly into the medical industry's lobbyists. So you got two big titans fighting, and there wasn't any way that was going to get passed, in my opinion. And it turned out to be correct, whether or not it was based upon my reasoning or not. That being said,
probably specified first-party property losses arising out of homeowners or building owner property policy, something along those lines.
The bill that eventually got enacted, yeah.
Yeah.
So since they couldn't go and completely prohibit the use of AOBs under the guise of being consumer protection, which some of it is, but some of it is so stringent, it's not really reasonable. It's just trying to make it impracticable to comply, which is kind of their goal, or to trip you up that by the time you go to file suit, you miss one little procedural thing, and then they render the AOB invalid, which then puts the contractor on the hook for attorney's fees. It's kind of how the whole thing's set up. But at the time an assignment of benefits is executed, you also have to have contemporaneously therewith the detailed line item estimate for the scope of work to be performed by that assignment of benefits contractor. So this did a couple things to contractors. Number one, generally they don't want to put the time into writing an estimate until they know the homeowners actually signed up with them. Because if you're actually putting together a legitimate estimate, it's a little bit of a laborious activity because most of these contractors that specifically do insurance work, they know more or less it needs to be put together inside Xactimate because that's the industry standard adjusting software. So number one, already at the time that they're signing up with the client, you got to have that estimate together. So that's a pain in and of itself.
Yeah.
Then from there, all the other procedural requirements in there, I'm known for going into the weeds. Remington let me know not to go into the weeds.
Yeah, you're good. I think also one of the biggest reasons why maybe it has slowed down AOBs in Florida is the fact that the shift of attorney's fees occurs now in AOBs that are signed up post July 1st, 2019. And I think that's a big deterrent for them just to run as many claims as possible. Do you agree to that?
Yes and no. I mean, the shift in attorney's fees really, for all practical purposes, if you were an assignment of benefits contractor that actually ran legitimate claims, not bullshit claims where they're frivolous, overestimating, remediation shit where it's 50 grand for 2 days worth of work, bullshit, stuff like that. If you're running legit shit, in all honesty, sorry, made everyone laugh.
It's just my new slogan.
Yeah, it's funny.
All good adjustments. We run legit shit.
Hey, Shelton Law, we run
That's
legit
all the contractors give us.
Yeah. But that being said, if you actually ran legitimate claims, that fee shifting statute doesn't really, unless you're just someone who's just has it completely personally risk adverse in general,
Right.
It really doesn't make that big of a difference because the percentages we're going in, I'll have a $150,000 tile roof claim here in Fort Myers, right? Well, we're working off of basically a below the deductible underpayment or a complete denial. So if we go and win for a roof replacement because the tile's discontinued, because we're either going to win or lose the claim. I know that's an obvious statement, but what I mean is there's not really much of a middle ground for a repair as much. We're talking about all out win or it's completely denied. So the percentages don't really matter because if you get the W, you're obviously clearing that 50% mark because they were basically starting at zero anyway.
Yeah.
If that makes sense. So but for contractors, here was one big thing that was a big deterrent to AOBs is the number of contractors I talked to that after this was enacted, everything was basically spread around that you can't do AOBs in Florida anymore. And I think probably what happened is people looked at this, realized how hard it was to comply with, giving the homeowner the ability to cancel in 14 days without any recourse, which I don't actually personally have any problem with. If you can't keep a customer happy for 14 days, you probably shouldn't be their contractor anyway, in my opinion. But yeah, those things were the bigger impact to where contractors just thought by common use and terminology, people spreading it around, oh, AOBs are invalid in Florida now. So I've actually done a lot of educating of, no, they're not invalid, but if you want to run AOBs in Florida, you better have your shit together. Because what it did is it eliminated your random roofer on the side to get BS AOB agreements and the storm comes through and jump on it and then kind of tie up the court system with stuff like that. It really takes a legitimate business model to operate AOBs in the state of Florida now.
I love talking with Dale about issues and matters and law and business because he will shoot you straight. He is not going to fluff anything, sugarcoat anything for anybody out there. And Dale, one thing that you said was risk adverse, and some of the contractors are just scared to maybe file suit just because they won't hit that threshold in which they'll be on the hook for attorney's fees. And also, this kind of ties back to this new bill that was drafted, in which they're trying to do an hourly, the Lodestar formula, if you will, in which it kind of takes the high risk, high reward from plaintiffs' attorneys in the state of Florida. I have a quick story on this.
Oh, no.
Dale and I were, I'm not naming any names whatsoever.
Dale and I were confidential.
Yeah. Dale and I working on a case together. And we had a co-counsel involved on a particular case. And in that case, it looked like there was the potential that we were going to have to eat tens of thousands of dollars in incurred cost on something that we had zero control over. And we were having the discussion, and co-counsel that we were co-counseling with is kind of really worried about something. And Dale, about the tens of thousands of dollars. And Dale looks over at him and goes, look, you're in a contingency fee basis. We're in the big boy world. It's either you put on your big boy pants and can take care of big boy losses, or you need to stop doing this. And I lost it. I was like, that is exactly right. And
that is like, not what the fuck we signed up for. Get out of here.
Did they quit instantly? I mean,
he actually put on his big boy pants. Did they hand
in their legal pad and walk away?
No. To their credit, they picked up their big boy pants and ran with it.
And he goes, this is what we signed up for. This is what we did. So we have to eat.
And actually, Rem, this provides me with the perfect segue, because I stole that line. Who did I steal that line from? What I consider to be the gold standard for running assignment of benefit claims as it relates to how they treat the underlying homeowner and protecting them. And that's AJ Wells Roofing and Construction in Jacksonville, Florida. Arthur Wells has owned that company for a very long time now. He put a lot of trust in me when I first opened up. He allowed me the opportunity to work on his claims, and it's turned into a great long-lasting relationship. And I've seen that man behind the scenes when I got a call and give him bad news, especially on a claim where he's run it cost incurred. Basically, he already went and did the work, even though the claim and coverage was still pending, to make the homeowner whole, so that way they can live in a watertight house. He took on the risk. Sometimes stuff slips through the cracks on the front end, and he goes and does cost incurred on an ACV policy. Well, there's no matter of legal stuff I can do that's going to get him made whole. And I'll have to make those calls and say, what do you want me to do, man? And he's like, just settle it for the best you can. I get that I can't get it all. I just need to put my big boy pants on and deal with it. At least we made the homeowners whole. He doesn't go back on the homeowner and try to get more money. He takes that as a lot. It's just part of it.
But just to finish off the story,
Dale,
no, you're good. And that's a great segue into the AOB conversation that we were having. To finish the story, Dale, and co-counsel figured it out, and it was A-okay. Just want to let all the viewers out there know. The ending was good. All right.
Yeah.
It was quite awesome, actually.
It was quite awesome. I agree 100%.
You ended up making money on it.
Yep, for sure.
Well, that's good.
For sure.
Yes.
So
looks like
what
we
are
got
some indicators that an insured attorney may be sitting on a claim opposed to pushing for a reasonable settlement and or trial as expeditiously as possible? Indicators.
Give me a brief moment, because I want to be careful, because it's weird, right? Depending on the circumstances of the underlying claim, one thing could mean two different things, right? One action or inaction could be reasonable in a certain circumstance and unreasonable in another. So I know I'm starting this out, unfortunately, with the cliche attorney answer of it depends, which you can ask Rem. I go above and beyond to not give it depend answers, but it does depend here. But this is what I'll do. Let me give you I'll lay out a few facts of like a really simple case, and then you can look at some indicators based upon that. I will caution anyone, as a case gets more complex, I don't think you can extrapolate out my general reasoning here to necessarily apply there. But okay, let's say we have a straightforward, a lot of insurance companies, the desk adjusters will have initial authority at somewhere at the $40,000, $50,000 mark. Okay, so we're going to talk about a claim that's, say, $35,000. at $35,000 for the claim with the way attorney's fees are, there's a lot of leverage once you file suit to get it settled, because the ratio of fees to the underlying dollar amount puts a lot of economic pressure if they're making a sound business decision on the insurance company to go ahead and settle. I mean, I had one, for instance, let me give you the perfect example. This actually just occurred last week. $23,000 shingle roof claim. And the adjuster working on it ended up getting it to pre-suit mediation. I ended up sitting in, I was already on the case, and the adjuster gave his opening statement. And then I quickly jumped on and said, hey, this is a take it or leave it offer. If you go ahead and pay the full exactimate right now. And he was like, well, no attorney's fees. I'm like, no, this is a one-time take it or leave it offer. If you're willing to pay full exactimate on the face right now, this is settled. Otherwise, as you see, I just filed the civil remedies notice. My client's already given me his authority to file suit. We're filing suit tomorrow if you don't settle this today. So one-time offer, full exactimate. He said, hold on a second, let me make a call. Came back 90 seconds later, we're settled. Done. I mean, that doesn't happen all the time, but that's the perfect thing. But that's the
How do I do that?
You go get a law degree.
In Florida, Florida. Let's be specific here.
Go get a law degree.
Because that doesn't happen in Georgia.
Try that on the next roof I'm on with an adjuster.
Yeah.
One-time offer. You can get down off my ladder if you settle now.
So to go,
taking my ladder with me.
But Randman, so so that example I just gave, Randman, is a good way to see the power of the economic pressure that can be applied with the attorney fee statute. So let's say let's carry that same hypothetical forward. Simple, straightforward 3-tab roof, clear wind damage. Actually, the adjuster damaged one of the tabs during his brittleness test and then tried to deny it.
Let's not go there, right? Let's not do that, Matt.
And a video about that last week.
So let's say we go ahead and we ended up filing suit. Okay, so hypothetically in the situation, we didn't settle it at pre-suit mediation. I file suit on it. And a claim like that, if we're at 4 to 5 months in without a legitimate settlement offer on the table or some really good back and forth, and here's a good thing to look for too, is your attorney actually hiring the appropriate experts? On our cases, if we don't have an engineer on the claim by the time it makes it to us, it's within the first 3 months that we're generally putting an engineer on our claim. Now, give your attorney some leeway here on the timeline of getting it, because there's not a lot of engineers in this field that have a lot of open availability. As long as they're actively trying to schedule it with their own engineer to build your case is what you're looking for. And I guess that would be one of the signs of, quote, sitting on it a little bit, is if they're not really building your case. I would be asking, what information or due diligence have you done to, quote, build the case? Some of the signs is really where they just want to sit there and kind of make phone calls, go through random, file motions on things that don't really ultimately matter, but you can legally justify the filing of it kind of thing. But it's really, you're kind of looking at the timeline. If you have a sub $50,000 claim, and this is all premised upon, I make sure I vet cases before I take them on, so I know the facts are good. If you have a marginal claim, my analysis here is out the window, right? An insurance company is going to sit on a $1 claim or $1 million claim the same way if it looks fraudulent or illegitimate. That's just going to happen. But if you have good facts, right, a legitimate good claim, yeah, I'd be looking for movement by that 4 or 5 month mark of, what's actually going on here. Beyond that, man, I really, Randman, as much as I want to, bud, I don't want to sit here and just put out more generalizations because it's so fact specific. If you think someone's sitting on your claim, I would suggest you to just reach out to an attorney and ask.
Call him out on his bullshit. Be like, dude, get off my claim.
And
I would say do some due diligence before you do that. But yeah. There you go.
And here's just an example. If you're a public adjuster, any state, let's just say Florida, because we're talking about Florida and talking about this bill, and you're a public adjuster and the insurance carrier has provided a reasonable offer for the client or policyholder to settle on. However, instead of conveying that offer to the actual policyholder or homeowner, their client, they're scheduling depositions. Now, to me, and again, facts are differently, but I can tell you this: if I have a reasonable offer on the table, and I'll speak for Dale too, if he has a reasonable offer on the table, he's going to be on the phone with his client trying to get this thing settled rather than worrying about deposing Haig. But somebody if they want to pat that file, is what defense counsel calls it, patting the file, adding the hours. That's what they would do.
Maybe you guys do this far too often and it's become old hat at this point. But if I have the opportunity to depose Haig, I'm taking it.
I did it this morning.
I mean, that would be the most fun 7 hours ever.
I did it this morning.
That probably wears off, my man.
Probably.
No,
Remington keeps telling me that I can come in and sit on a deposition for any of my files. And I keep telling him that if I do that, I'm going to bring a beer in. And every time he asks a tough question, I'm just going to open it real quietly, take a sip, a little smile on my face, watch them sweat it out. And they know that every time it's because there's a rough question that I know that they're going to have some issues with. And I'm looking forward to the answer.
I love it. Whenever you do that, I want to be part of it. I just want to watch.
Exactly.
There you go.
Hey, Rem, going off what you were just talking about, we've been kind of harping on the plaintiff side of things. I think something that's important to be put out there, if we're speaking objectively right now, is let's just look at the law firm economics on the defense side in terms of why delays there. So a lot of people get hung up on just the insurance company doing extra stuff to delay on the claim.
Right.
There are certain general, I'm not calling anyone specific out because once again, I don't need a libel slander suit after me, but I know this happens, right? And the defense firms that work for these insurance companies, the insurance company has all the leverage in terms of pricing. They have a really beat down hourly rate because it's supply and demand. The insurance companies can feed these defense firms with basically an unlimited amount of claims. So they have a lot of leverage over the hourly rate. Well, when I first started out doing this work, there would be situations to where I had the case perfectly set up. We're trying to do settlement negotiations, and then they file some random bogus motion. And I'm reading it, and it's like, I see that you technically satisfied the frivolous standard. It's not frivolous, but there's no way you legitimately think you're going to win on this if you know what you're doing. So then I don't understand what's happening. So I go through, I'd win on it, and then all of a sudden they want to settle. And it didn't make any sense to me. I'm like, why do we keep doing this if you know you're going to lose anyway? Well, then I talked to someone a little more experienced, and they said, well, the attorneys at the defense firms have hourly quotas put on them. They get paid an annual salary. The only way that law firm's profitable on the defense side is if they bill more hours than what they're paid in their salary.
Yep.
At the hourly rate. So, and I know friends that are with defense firms in various different areas of law, all defending insurance companies in various types of insurance situations. They have hefty hour quotas put on them, especially if you're trying to make partner and stuff. So what I started to realize was when I first filed suit, I got to go play the song and dance for the first little bit because it's not even the insurance company necessarily delaying. It might be opposing counsel needing to meet his hourly quota by filing some extra stuff. And, I don't use 57105 is the statute for frivolous claims and stuff. We don't throw that around lightly. But we have utilized that because it's just egregious. You're really going to waste our time to come argue about something where the case law is perfectly clear.
And viewers, just to give you some context of that, is if defense counsel files a motion against plaintiff's counsel, Dale's client or my client, and we believe that this motion is absolutely just baseless, they know they're going to lose this. And in fact, we have orders from the court from these previous motions saying that they're going to lose, and they still go forward with the motion. We send them a letter saying, hey, if you still pursue this actual motion itself and I have to waste my time and resources on it, you're going to have to pay for it. And it would literally compensate me for my time for answering this frivolous motion. And just to give people context of what that means.
All right, we got a question I'm going to pull up. I'm not really sure I understand what it means, but what if they do deposition prior to any type of conversation with PA? Does that ever happen?
No, because if they're doing a deposition, that means they're in litigation. And what individual that's in litigation would then hire a PA?
What if he says follows up a thief claim? If
the
thief is the PA, maybe he'd be deposed next.
I think maybe he's saying deposition as in examination under oath.
Yeah. So here, okay. So let's be clear on two things. Prior to filing suit, the thing that you're probably used to seeing is what's called an examination under oath. The thing that gives them the right to do that is not the Florida rules or the state rules of civil procedure that gives you right to go take a deposition. It's actually the contract policy language. In there, there's a right for the insurance company to take an examination under oath. And the best way to think of it is a little bit of an informal deposition. You're still under oath, but the insurance company is just part of their reasonable investigation of the claim. Sometimes it's used as an intimidation tactic. Sometimes it is research. That being said, talking to you then prior to any type of conversation with the PA, that wouldn't surprise me. I could actually see them just wanting to talk to you in an EUO prior to you have legit representation and get you to trip up. Now, once a lawsuit's filed, it's very different. Now it's attorney represented. Everything has to go through the law firm and everything else. So, sorry, Borrow Mike. I'm just trying to figure out exactly what your question's asking.
Every time we've gone to an EUO, other than the first time when I realized that I should not be doing it the way that I'm doing it and completely changed my entire procedure around it, we've got an attorney involved. And once the attorney is involved, it's very rare that the attorney then gets removed from the process at that point. The insured is probably very comfortable having an attorney there, or the carrier has lawyered up and you'd want to keep the attorney involved. It'd be rare to even go back to a PA after an EUO for that reason. Yeah. Unless the PA does the EUO, and they shouldn't. Don't ever do that, PAs. It's a terrible idea. Even if it worked for you that one time, shut up. Don't do it. That's all I have to say about that.
And that's exactly, I mean, there are templated questions that, and I've never had it where somebody other than an attorney for the insurance carrier has actually asked the questions in the EUO. Have you ever had it where it was an adjuster?
No. Oh, no.
It was always an attorney.
Yeah, it's always an attorney.
Yeah.
So they've lawyered up. If they lawyer up, I mean, I've won against lawyers in the past as the insurance representative, and the carrier had an attorney. That's happened many times. But after an EUO, once the EUO happens, PA and EUO, and they start leading the witness, I can't do shit.
Yeah.
What am I going to be able to do?
But here's the difference.
Objection.
Here's the difference, man.
I'm not an attorney.
When you're talking about a claim with defense counsel, and it's just it's not in litigation, right? Obviously, but it's just a claim. You're still in your field of play, right?
Sure.
You got the policy. You know the policy better than that actual defense attorney. And you're using that, and you have your weapons, you're putting experts on files, and you're being successful. When you step inside of a EUO room, you are not in your field of play anymore. I'm telling you, they know exactly what questions they're going to ask, and they want you to step in that trap and you be done. You know, and it's just
it's an ugly scenario too. Are you saying that the damage occurred 5 years ago when the hailstorm came through? Notice I'm shaking my head, trying to lead you into saying yes. Yeah. Oh, I'm smiling too, because it's just a friendly question. There's no trap here whatsoever. It's okay. Go ahead and say yes. Yes, I do. Of course. Mm-hmm. Thank you.
Here's another question we got from JS. It is, what are the indicators of appraisers sitting on claims appraisals?
Lack of doing anything for 7 months.
Well,
that's a good
indicator. Not meeting out at the property if it's necessary to do so for an extended amount of time.
So if we're talking, are we talking about an actual appraisal situation, not just simply like an adjuster coming out doing the adjustment of the claim, but officially it's been thrown into appraisal?
Correct.
Yeah.
So in the policy, there's generally a requirement that the appraisal be concluded within 60, 90 days, something like that, whatever it may be. So
not in a lot of states. Most of the appraisal provisions that I've seen don't have any kind of a time frame other than the selection of the appraiser and the umpire.
So here's what I would have to say is it's a combination of complexity, availability of appraisers, because like right after Michael, a bunch of stuff went to appraisal relatively quickly, but we're in the panhandle. Not a lot of people came into that area to work it on that side of things. So simply just trying to get two appraisers on both sides to have the availability to go meet there in the middle of kind of nowhere on certain claims, that caused delays. So that's not necessarily sitting on. But let's say you're in a normal kind of city, Tampa, St. Pete, Fort Myers, Naples, Jacksonville, something like that, right? Where it's more populous, straightforward residential claim, especially if it's roof only or exterior only, you don't have a lot of water penetration and stuff. Because as soon as water enters the home, water goes a lot of places and that can start to make a lot of things more complex. But if you're exterior only, if that whole thing's not resolved inside of 90 days after the start of appraisal, like something weird's going on. Like I would start to inquire. Now, that doesn't mean that anyone's sitting on it. But here's the thing. Appraisers they're not financially incentivized to necessarily sit on appraisal claims as far as I understand.
I think there's a way that they are. Especially if they're the insurer's appraiser. A lot of times just dragging out the appraisal, the delay tactic works during appraisal just as much as it works during the normal adjustment phase. If they delay long enough that the insured gets just worn down and wants this over with, the insured is more likely to tell their appraiser to just settle the thing out. I mean, I've got an appraisal right now where the opposing appraiser is clearly delaying everything as much as possible, even fighting the use of the umpire, doesn't want to get the umpire involved because they haven't established what their differences are yet, but refuses to mention what his differences are or what his actual opinion is of anything. So there's definitely incentive, I think, if the carrier is pushing the opposing appraiser to delay things anyway. It definitely seems like that's happening. There's no way we could prove it.
I don't 100% disagree with you, but just on some nuances, I think this is good for people to hear. So financially, it's my understanding that appraisers are being paid most of the time by the insurance company on a flat fee basis, right? So at least in theory, there's no monetary incentive to string it out. They don't get more money if it's less. They get paid the same flat fee. So you would argue that they're actually incentivized to get it resolved quickly. But if your whole job, and this is speaking to your point, if your whole job is running appraisals, and I'm just letting everyone know in this industry, there's not really people that do appraisals on both sides. There might find some umpires that cater to both sides, but you kind of stick in a lane, right? The insurance company is not going to hire a plaintiff's appraiser, and a plaintiff's appraiser is not going to hire an insurance company's appraiser most of the time, all else being equal. So with that being said, I think in my experience, what I've seen when those situations like what you're describing coming up, Matt, is it's ego, it's pride. Like they want, you get a lot of people that, now I have authority. We're not doing it because I said so.
There's a total power trip involved. That's 100% accurate. Yeah.
So I think we run into some of that, but generally, but that being said, one of my appraisals from Michael, if my clients are listening to this, I am still sorry. This thing took god awful forever. Now it didn't help that, and this is a good example of complexity. So the co-insurance clause came into play. So two separate things were getting appraised, and we'll just not go into all the co-insurance stuff. It'll get kind of in the weeds, but I'll put it simple. We had to appraise the actual amount of damage to the property, like normal, but then we also had to appraise the value of the property right before the time of loss to determine how much the co-insurance would apply. And this is the funny part, is the way the math works. Insurance company wants to argue amount of damage is as low as possible, but the value of the buildings is high as possible. And we're essentially arguing the opposite, right?
Yeah, it's hard to find an appraiser that can distinguish that and bifurcate it. Honestly, we've decided in the past to do it as two separate appraisals. Do the first appraisal as the amount of loss, the second appraisal, or it doesn't matter which one you do first, really, but have two separate appraisals, two separate appraisers involved. And what we found is when we do that, the carrier will still name the same appraiser on both. So the appraiser on the opposite side has a hard job to deal with, but our appraisers, because they're bifurcated, is a little bit easier. It's really kind of interesting to watch the frustration on the face of the opposing appraiser in a lot of those.
Yeah.
I'm told.
Somebody could pad a file on that as well, doing 2 appraisals.
Yeah.
I mean, really, I've done it 2 different ways. I've paid an appraiser for a flat fee, but typically I feel as if I pay, in Georgia anyway, pay an appraiser on somewhat of a hourly basis. And I will get a bill. And if the appraisal isn't even finished, at the end of the appraisal, I'll get another bill. Do you get hourly appraisers that are hourly, or do you?
I've never hired an hourly. I've always hired a. No, hour. Yeah. I'm sorry. I've always hired hourly.
Okay.
There's usually like a retainer amount that they have to start off with,
Right.
4-hour minimum or something along those lines.
Right.
But it's always hourly.
I was going to say, I was like, I want to know who your appraisers are. I need to get their information.
Flat rate would be cool. They can't do a contingency, otherwise they're not disinterested.
Here's the deal: if you trust the appraiser, I don't care if I pay them an hourly. You know,
That's fine.
That's fine with me,
Pretty
100%.
standard. This is interesting though. Can they? I've never heard of anybody charging for every email or phone call. I mean, technically, a lot of them do anyway. If they're charging hourly, they might use emails and phone calls to add up their time.
Oh yeah, I think they do charge for.
Every time I write an email, that would be put in as 15 or 30 minutes, depending on the length of time it took me to write the email.
Absolutely.
So I think that really is built in.
That's what attorneys do
I'm going to go
constantly.
back to this question. We're going to go back to the EUO issue. In Florida, when an insured is asked to sit for an EUO, is the insured able to ask for the EUO questions be sent to them to answer privately, then notarized?
Unless it's in the policy, I would say absolutely not.
Absolutely.
No.
Or if
not.
it's stipulated outside of the policy, that's how they can answer the questions.
So,
Well, I mean, if there's
let's start here.
extenuating
Theoretically, you could ask for that, right? But let's actually
Right.
stop and think about why they want to take your EUO, Ram Man. They want to take your EUO so that way you're in the hot seat, under pressure in real time, not prepared, and you're going to get asked, as Matthew was pointing out, a lot of nice questions with smiles on the face to where you feel nice and comfortable, and they're not there to help you. So by wanting to go ahead and do them in writing and send them in the comfort of your home when you're calm, cool, collected, that takes away their competitive advantage. That's why they want it. And also it's also an intimidation tactic as well. A lot of people just get really, really nervous, understandably, about being put under oath and having an attorney ask you questions. That just happens. I've had cases that I've been forced to settle by the client simply because one of the spouses didn't want to move forward with their EUO or deposition, and the other spouse, kind of just creating a happy, home situation, said, "Hey, just settle this for as much as you can. This person's not going to get deposed." So it's not so much whether or not you can. I agree with the board here, if you want to call it that. 2 people I'm talking to, with Matthew and Rem. But I agree with them. Most likely you don't have the right to. And the reason you don't have the right to is because the insurance company doesn't want you to have the right to, and they write the terms of the policy, and your EUO is governed, generally speaking, by the terms of your insurance policy.
100% agree. And that's what I love about Dale as well, is I'll just give the answer. No. More than likely you can, unless it's in your policy. He likes to explain the A, B, C, D of why you come to the conclusion of no. And I love it. I was like, no, you can't.
My wife will tell my kids no because I said so.
Yeah.
And I like to try to explain why, because I think that their tiny little minds will understand the reasoning behind it. They listen to her more than me as a result. Anyway,
You had something on the bill.
this is
you wanted to
interesting in the
bring up?
bill.
Yeah.
It talks about the 60-day demand, and there's some language in here that is new. It says, if provided by an attorney or other representative, that a copy of the notice was provided to the claimant. The fact that it says or other representative definitely leads me to believe that they are allowing for a non-attorney to send in a 60-day demand for payment.
For sure.
I think that's interesting.
Yeah, well, I mean, if someone hired a PA,
Right. So that was always somewhat of a debate on whether or not the PA
that's
could
practicing
do that.
law.
This
Yeah,
provides a codified.
Well, here's the
Example.
thing, right? It codifies the ability to have that, but I don't think this statute in and of itself supplants the decision of whether or not someone's doing unlicensed practice of law. Now, the fact that the statute says that a representative different from an attorney can do it, gives strong argument that, hey, this is essentially, think about it this way. Real estate agents, right? They're
This is
permitted
such
to
a
fill
lawyer
out.
answer.
Do what?
It's such a lawyer answer.
That's what he's here for. That's what he's here
You want me to
for.
keep going, or
I'm just saying it says or other representatives.
no, but what I'm saying is whether or not a PA would actually be authorized to do it. I want to make it very clear for the PAs out there. Just because the statute implies that you possibly could doesn't necessarily mean that this doesn't cross the line of unauthorized practice of law.
Do you think it does?
Hear the same. Do what?
Do you think it crosses that line?
I think it matters exactly what, and I think Dale will say the same. He would have to read what the demand says for him to make that determination.
Here, I can actually answer a little more specifically than that, Rem. With what this statute lays out, it actually starts to lay out specifically what needs to be in that demand letter. So in my opinion, this was kind of the analysis, and I'll use a real estate agent as an example. So a real estate agent obviously has a form contract that they help fill in for a purchase sale agreement. Well, one could argue that that's practicing law. Well, if all they're doing is filling in stuff, like you'd have to have an attorney involved for every real estate transaction out the gate. That doesn't make much sense. So where it gets real tricky is, what if the real estate agent starts adding in their own terms and conditions, right? As a precondition to sale and closing, this needs to happen. Well, maybe that starts to look like practicing law, maybe it doesn't. But when they're just simply filling in blanks of information, that's generally accepted to be not practicing law. It's within the realm of their license. So if this statute, I'm not going to give a legal conclusion here, so no one hold me to anything. But if this statute sufficiently lays out line by line to where you can check the boxes of what needs to be included in that demand letter, well, an argument could be made that that's basically the equivalent of like a real estate agent in a property sale transaction, right? I'm just painting by numbers that the statute laid out. I'm not making an independent legal consideration. Because otherwise, this would be my thought on it. I think that should be allowed, because otherwise homeowners are essentially going to be forced to an attorney when some are uncomfortable getting one yet. So even though that might benefit me, like, I don't think anyone should be forced to an attorney. So if you have a competent PA that you trust to send in that demand letter, well, there you go. Now, what I will say to the PA is, if you keep reading in this statute, the ramifications of what happens if that demand letter is not sent in appropriately, and then the attorney goes and files suit, well, you could get your ass in hot water. So for practical considerations and liability considerations, I'd probably outsource it. So probably a good thing is, if you had a connection with a law firm that for $250, $500, something cheap, they'll go ahead and just send in the demand letter with no further commitment to the homeowner.
Yeah.
And then see if you can get it resolved. And
I'd
then
send it
obviously
to India.
Yeah.
So
That-
one of
that's a
the
good way to put
items
it.
that it says to do is you're supposed to name the alleged acts or omissions of the insurer giving rise to the action. If you're naming acts and omissions of the insurer, is that acting as an attorney?
That starts to get real gray, right? Now, you could argue that the acts and omissions language, I mean, it's kind of bad faith statute related. Department of Financial Services in Florida, you can go onto their website to file a civil remedies notice for the bad faith. And it actually lays out statutorily what are bad faith on a drop down, right? So in that context, you could argue, well, the PA's exercising some independent judgment as to which one of these applies, but isn't really making formal legal conclusions. Here, if the PA starts talking about how they breached the contract by these, maybe you start to fade over into that. If the PA is simply stating, hey, the roof had these damages that are clear and obvious, these were missed and not included on the insurance company's estimate, that's why we're going to sue you. Well, that to me seems squarely within the realm of what a PA is authorized to do. Once again, not making any legal conclusions here. No one tried to sue me for giving legal representation, but that's where, that's kind of where I'd see that. You know what I mean?
I just want an opinion. Do you think that okay, when you are a licensed public adjuster, then you are legally able to adjust a claim. Does naming when the carrier has breached the insurance policy contract, does that fall into the realm of adjusting a claim?
Yes.
Okay.
Mm-hmm.
So then the answer is,
but
it's not acting.
I mean, big picture, Matt.
Maybe.
A PA is a PA, so they can talk.
Possibly.
Hey, big
I'll give you
picture
pause.
wise, let me just say this real quick. Big picture wise, a PA is a PA. They have the license to talk and interpret policy. That is the main reason why they have their license, right?
Right. So if they are interpreting the policy by saying that the carrier is not abiding by the policy and breaching contract,
That's
if they use
adjusting
the
the
term
claim.
breach
So
of contract, is that acting as an attorney?
I don't think I would use that term. Just
What if
being
they
honest.
name a statute that they are violating that has to do with insurance?
Why not just use the phrase, you're not properly adjusting this claim? And
Under
this is
Florida
why.
law.
Yeah.
Under Florida law in general.
Because I want to say you're not doing this fucking thing in the statute. That's why.
This would be my advice is,
You know, I just want my email to just.
what we're really getting to here, Matthew, is you want your pound of flesh, and I'm trying to advise you as an attorney that pound of flesh is probably not risk reward worth opening the door to liability for unlicensed practice of law.
But it feels so good.
It's a bad business decision.
Big boy pants on, Matt, right? Make big boy decisions.
Look, I wear skinny jeans. Those are not big boy
I wear
pants.
skinny jeans.
And in today's day and age, those are still big boy pants. They just harder to get on.
Yeah, they just make your octaves a little bit higher.
Exactly. But that's what I was talking about earlier in the live stream when I said I think they're like implementing some ideas from the state of Georgia and other states in the Southeast and around the country is this whole 60-day demand. Obviously, we have to do that in Georgia to have account for bad faith, et cetera. And I just feel like the state of Florida plucked that from the state of Georgia, and now they're trying to push it.
So I'm going to go back up into this thing a little bit. There was a few other changes that this makes just to bring us all back to the whole purpose of our show today. This limits the time frames on filing a claim from 3 years in Florida down to 2. You have 2 years from the date of loss to file any property damage claim, not specifically wind and hail. That is one of the changes that this provides. Based on the language in this thing, do you want this to pass, Dale?
As a yes or no answer, no. And not really out of self-preservation. I think it actually harms the underlying homeowner. Let's talk just specifically on that change to 3 to 2. Let me walk you through a real legitimate example. Hurricane Irma hit down here in Southwest Florida. After Hurricane Irma, there was roughly a 1 to 1.5 year period where it was just unseasonably dry. Well, when you have Hurricane Irma come through and it damaged, these tile roofs, it's essentially 2 roofs, right? You got your mod bit underneath, then you're essentially mod bit roof and you stack rocks on top. Like it's a pretty safe way to protect your home, right? At the end of the day, we just made the rocks look good. Yeah. So when that happens, sometimes the damage is there, but most of the populace down here is elderly in age. And even if you're not elderly, how often do people just get on their own roof to go check stuff out? It doesn't really happen, especially a tile roof. So what happened was a lot of the Irma claims that we actually have, we're getting grilled on, why did you late report? Why did you late report? Well, our homeowners didn't become aware of it until stuff started raining. And then all of a sudden they noticed a spot, but without the rain, how would they know that this handful of tile in this specific valley hidden away was actually damaged? Right? So even if they submitted their claim initially, because it also applies to a supplemental claim, right? So in this hypothetical, the 2 years is for a supplemental claim as well. So they could file their initial claim because they noticed a few tile on the ground. Insurance company adjuster comes out, says, oh, yeah, you just need to repair a few tile. Oh, by the way, you're under your hurricane deductible. We can't give you any money. I'm sorry. They hire a handyman, goes up there, tries their best to kind of mitigate and put the stuff together. Okay, now they think everything's good because nothing happened because it hasn't been raining, right? There's no water you need water for the damn roof to leak.
Right.
So we get a year and a half later, it starts raining. Now all of a sudden it's leaking. Now they're trying to get people out there. Well, now you're left with this narrow window of needing to file the supplemental claim saying, hey, insurance company, we actually have additional damages, because most homeowners don't just pick up the phone when they see a leak and say, hey, I have a supplemental claim. They call a roofing contractor. The roofing contractor will often recommend a PA if they kind of are aware of the area of law and what we do.
If they're smart.
So then it goes through this process, and then we get to the back end to where now that 2-year window closes super tight. Now, let's be clear. The 2-year window or currently 3-year window for wind claims to file is a claim reporting period. The suit of limitations period of 5 years for a breach of contract claim in the state of Florida is still going to apply. But what it's going to, so you're still going to be able to file suit on something that was wrongfully denied, even after the 2 years up to the 5 year mark. But you're limited based upon the dispute that existed inside of that initial 2 year claim reporting window. And a lot of times people can't get a supplemental claim in time because they're just not aware that it's necessary. That being said, I don't think the claim reporting period should be the same as the suit filing period. I don't think the insurance company should have to wait on 5 years of unknown what's coming in after a storm, right? I think that's too much, honestly.
I think 3 years is reasonable.
No, I actually like 3 years.
I wish it was 3 years.
To be honest.
Yeah.
I really think 3 years
weird.
is reasonable.
It's 3 years to file a claim in Florida. You have 2 max in Georgia to actually file a lawsuit.
And that depends
that's
on the
big
In
policy.
spectrum.
Georgia, they can limit the claim filing to 1 year, right? Per
There
policy.
are policies
absolutely.
in Georgia that require that you file the claim within 6 months, depending on the cause of loss.
Just
There are
absurd.
policies in Georgia that have a suit limitation of 1 year, but you can collect RCV benefits up to 2 years after the date of loss in the same policy. Makes no sense.
No, that's completely
That
illogical.
makes no sense.
And it's not like these are smaller insurance companies. These are big dogs in the state
That's
of Georgia.
State
that
Farm,
are doing
I'll
this.
say.
Yeah, State Farm. Exactly. I mean, it is what it is.
But that's
Unless
how
it's a
they're so big.
fire, you get 1 year.
That's it.
Typically.
For lightning.
Fire, lightning. Come on, Matt. Give me some credit here, man.
Right. I mean, that's why all the firebenders also shoot lightning.
Oh yeah, that makes sense.
That's my inner nerd is showing again.
But is there anything else on this bill? I mean, I know we've hit the broad strokes, so to speak. Dale, do you know of anything else that we haven't touched base on?
Certainly, there's things we haven't touched base on.
Yeah.
Quite honestly, it's going to start to get into stuff that I think people are going to glaze over in the eyes.
Yeah.
So if you got some other bigger broad stroke topic, that's probably better for this context. But
Yeah, I'm going to bring up one thing that's in here just because a lot of our viewers are roofers. This does have a section that specifically does not prohibit the use of roof payment schedules in policies. I don't know why they bother talking about it, because it just says that it doesn't prohibit them from using it.
no, so
But if they are going to use it, it specifies how it's supposed to be used.
correct. So the reason that in my opinion, the reason that it's in there, and I'm deducing some of this from some of the language they use, which says irregardless of an RCV policy or the application of ordinance and law coverage, right?
Yeah.
So right
Yeah.
now, if they wanted to put that fee schedule out there, we'd just be arguing that, okay, under regular coverage A, you can apply your weird scheduled ACV to it, but that only applies to the 25% that got damaged. Florida Building Code requires the other 75% to be replaced to get everything brought up to actual current building code standards. Therefore, the other 75% doesn't fall on this schedule. It's actually an ordinance and loss damage. So this statute, what it's allowing them to do is give them a complete right to offer to the insurer, to the homeowner, the insurer, insured rather, my bad, the option. We will reduce your premium by however much if you're willing to allow us to add this ACV schedule for roof payment into your policy. It's the same exact way that they did the AOB law, right? The AOB law didn't allow the insurance companies to just completely exclude assignment of benefits from every single policy. What it allowed them to do is validly prohibit assignment of benefits in policies so long as the homeowner knowingly signed a waiver of that coverage. The same way that the homeowner has to knowingly sign a waiver of ordinance and law coverage. And it's kind of the same thing here. Here's
Guys,
the problem is when it gets implicated, man, when it gets implicated in practice, consumers are not being fully educated as to what the hell they're giving up. All of this shit sounds great in theory, that they get to choose, it's the homeowner's choice. But when there's a complete disparagement between information between the parties, and you have insurance sales agents, and I'm not even talking about people intentionally doing wrong, they're just not fully informed. I mean, hell, there's attorneys that I know that do this area of law that don't understand this shit, right?
Right.
So you expect the insurance agent on the front line to keep up with ever-changing law and be able to intelligently explain it to the homeowner?
All they know is they're selling an RCV policy.
Yeah.
Right.
And hey, I can give you a premium discount if you sign this one thing. Here's $50 off the premium. Oh, by the way, when your loss happens, we're only paying you for 50% of your roof. Deal with it. Hopefully,
Guys, Dale, you hit it on the head. And let me tell you this is what's going to happen. If an individual, a policy holder, let's say he has a $500,000 house, he signs the premium reduction to have ACV coverage on his roof system. Another Hurricane Matt comes through and hits the house. They need a full roof replacement. The roof itself costs, let's just say $100,000 because it's a nice tile roof. Okay. He only gets ACV coverage for that. However, he has a 7% hurricane deductible on that policy. He's not getting a dime.
Nope.
He's not getting a penny out of that.
Real quick, let me add in on this point. Real quick, Rem.
You can pay hourly. Loan Star.
Oh, yeah.
Mortgage companies beware. Mortgage companies beware.
Yeah.
Your loans are secured by this residence. You want what is a requirement to have your loan? You have to have insurance coverage.
And you have to have RCV coverage. Fannie Mae and Freddie Mac both require RCV coverage on the policy if you have a mortgage.
And
they're sold as RCV policies.
And that's why it's written like this. But mortgage companies beware. You're going to have a massive loss come through. It's going to get over depreciated. The part that's going to be paid for is going to be less than deductible, like Rem just said. I don't know of anyone else that uses this terminology, but I call it a constructive denial. Technically, they opened up coverage under the policy. But at the end of the day, when they adjusted the claim, guess what? The amount that's owed just so happens to be less than the damn deductible. How much money gets paid out? Zero. What the hell does that feel like to the homeowner as I'm trying to explain to them? Technically, they opened coverage on your claim. They were willing to pay this much. It feels like they got fucking denied, right? Because they didn't get any damn money.
They always say denied either way.
This is what's gonna fucking happen. And mortgage companies, beware. Like, I don't know why you think the insurance companies are looking out for you. The AOB law removed so much needed contractors that can come in and quickly keep these properties from getting mold damage. Like Sally claims I got right now. They can't get anyone to do remediation because the AOB's capped at $3,000. Now homes are filling with mold.
Right.
People can't live there. Actually, one of my clients I fucking bought on Amazon and sent them 3 humidifiers just to try to, air cleaners or whatever. So I felt so bad. They're an elderly couple that take care of their 3 grandchildren. They have nowhere to live. ALE money's not getting paid out. This is the shit that fucking happens. But then we all want to act like insurance companies do it. No, they're a business. They're in it to make money. So are we. I'm not doing this for shits and giggles. I'm here to make money. But let's talk real about what the fuck's actually going on out here. I mean, it's mind blowing.
When do they get to call it RCV policy? Does every coverage for A and B have to be RCV for it to be an RCV policy? If they can reduce coverage under A and B for anything, and that reduces it down from RCV, then is it really? It's not still an RCV policy.
No,
it shouldn't be. Just because there's an exception from an RCV policy, it just doesn't make sense to me. And one day they're going to have to figure that out.
They're pushing form over substance right now. And the fact that it's RCV is illusory at the end of the day.
I did the same thing for my wife.
What's that hat?
It's an okie doke.
It's an okie doke. Yeah, it is a okie doke.
Go in the okie doke.
No, Dale, I never thought about that on the sense. I mean, we've talked about it, but the fact that this new bill could really affect the banks the way it really could, it's pretty astonishing where you should have plaintiffs, homeowners, policyholders, and banks going against these insurance carriers when really that's not the case. It's big corporations versus small guy when it should be different.
This is so weird.
Rand man, you are spot fucking on, my man. That's exactly what we need to be doing.
He's right. I posted on our Georgia Restoration Collaboration Forum some articles about Freddie Mae and Freddie Mac about 2 years ago, talking about this very issue, that because they are requiring RCV coverage, the mortgage companies should be looking into whether or not these ACV only policies or certain coverages, if it reduces down to ACV, it causes a problem for the properties that they have a lien on. One of the conversations I had over the weekend is, when is it going to come to a head? What storm, what event is going to cause the mortgage companies to realize the shitstorm that they're actually in? And it might be Texas.
If this bill gets passed in Florida prior to next storm season and something actually hits, especially in South Florida, where it's all tile and the biggest depreciation schedule on here is for freaking tile, you're going to see it. Especially post-COVID, we're likely going to have a little recession coming up, most likely, especially in the real estate market. There's an artificial bubble right now, especially down here. Everyone's jumping coast from East Coast to West Coast because you get more freedom. It's not as locked down or whatever with COVID restrictions. So you got all this artificial bubble going on. On the same time, how many landlords can't evict right now that aren't making mortgage payments? Yeah. Right? There's this whole bubble propped up. You pass this and basically any roof claim is not going to have coverage in South Florida between the hurricane deductible and the depreciation scale. I mean, here we are.
You're done. Let's be fair. This doesn't put that into every policy. It just says that it doesn't restrict policies from having.
Okay. No, but the idea that it's going to be more prevalent across the board in the state of Florida is a reasonable statement.
I mean,
okay, let me delay it enough time for them to get it into 75% of policies, and then the storm that hits after that is the one that'll make it bubble up.
It lays the framework for it, so the policies will start having it for sure. You'll end
but let's make it clear. It's not a mandatory, look, we're only going to pay ACV. Look, the insured has got to check off a box, okay? A box that, like Dale said, they probably don't know and don't understand. They just look at
all they see is they get a premium reduction.
Exactly.
All right, so this bill is ugly for policyholders. I think we all agree, or at least everybody that's on this show does. It's not a good bill. It's not really going to help anyone, not in its current format. It doesn't solve the problem that it's trying to solve. It just causes more headache and sets the framework for future headaches down the road. How far along is this? Is this likely to pass?
Well, I know personally, I was actually just talking to someone that's getting called into a kind of behind the scenes meeting because they're getting tired of getting hammered with lobbyists and attorneys. Because I actually asked, would you like me to go? And they're like, no, the reason I got the foot in the door was they didn't want to talk to any more attorneys. Hey, fair enough. It actually made me happy to hear that. So my knowledge up to this point is this has been overwhelmingly, unsurprisingly, just supported and pushed forward by the insurance company. I haven't heard any real compelling reasons under general guise of premiums will be lower eventually because of this. I freaking hope your damn premiums could be lower if the combination of a hurricane deductible and this depreciation schedule equates to you don't actually apply coverage to any fucking roof. That's what's going to happen. I hope you could charge less because you're not covering my damn roof. Like,
absolutely.
It should be a lot fucking less.
I was hoping Josh would jump on. I was about to tag him.
Hey, Dale, what was the phrase you call that? When it's under the
denial,
constructive denial. I love
beautiful.
it. That's why I love this guy. So
I'm going to write an article about constructive denial. I'm going to ask you a whole bunch of questions.
Let's do it.
I'm not going to quote you. I'm just going to act like it was.
Love it. Hey, steal it. I'm all about it if it works. I don't need personal recognition. Let's just make everyone do better in the field.
There you go.
I was talking to Josh about the mortgage company issue this weekend, about the very thing that we brought up. I'm glad you got on, Josh. The idea that your property improvement depreciates while your property appreciates. It's not intuitive to the reasonable individual. Property improvement I need to drink more beer.
Yeah. So Joshua is saying like the property value, but I think what it's saying is the actual the lot itself versus materials that have been on a house for 15, 20 years. Yeah. Right.
Yeah.
There's a difference between the two.
I actually didn't read his question before we put it on. It's not a question at all.
Yeah, it's a statement. And I
was totally
see what you're saying.
I put him on because of our conversation over the weekend. I was anticipating an actual question.
There we go. And you failed.
Hey guys, I got about 5 minutes. I got an 18-month at home, and I take my daddy responsibility really seriously. So I'm about to cut out here in a little bit. You got anything to?
So what do you need them to do? Are you fighting against this bill yourself? Are there organizations that are doing something on this that you're?
Yeah, there's other organizations pushing it forward right now. I've been very blessed with a lot of work here in the state of Florida, and my clients deserve all of my time and attention right now because these cases are really hard fought. So. here we are.
Time for this. That's what he just said.
No, I'm aware that there's a lot of other people actually stepping up and starting to fight it now. So this one's not particularly my fight, other than what I'm putting forward right here for people to hear. But this doesn't help overall. That is for sure. I don't think this is going to help. This is going to help the insurance company. It's certainly not going to help the consumer.
Dale, thank you so much for your time, buddy. Really much appreciated.
Absolutely.
Man, the knowledge that you have, and I know you and I have worked together on multiple cases and everything, and what you say carries a lot of weight. And
Hey, if somebody wants to use you or get involved in a claim with you, where do they go?
You can go to sheltonlawplc.com. I'll let everyone know the website there is not super stellar. I got blessed with a lot of work really quickly, and the website's a placeholder because I got filled with business right away, right out the gate. So I never really had to go change the website. There's a phone number on there. You can call the office as well. Or you can just email info@sheltonlawplc.com. Someone can reach out to you there. But we don't, we really don't spend any money on advertisement. We just have a lot of good connections made with good referral sources, and we just focus on doing a good job and not advertising. So, but those are the ways to reach us.
And also all the viewers, if you want to get in touch with Dale, just for some reason can't, get his contact information, contact me, and I promise I will connect you with Dale, and we will make that work.
That works too.
Yeah.
Thanks, Dale. We really appreciate your time.
Thank you, buddy.
Yeah, absolutely. Let me know if you want me to come back on. I can get aggravated and yell some more.
There we go.
that.
We can do this.
Yep. All right, take care. Dale knows his shit.
He does.
Dale is very passionate.
I told you.
Dale gets in the weeds.
He knows his stuff. He's literally one of the smartest individuals I know.
Yeah.
It really is.
I like the guy.
Yeah.
I got to share something before we get off, just for the heck of it. And I've never shared my screen on this show, so this will be interesting. Let's see if this works. Share screen.
I feel like we're on Zoom. Share screen.
I don't know which screen I'm sharing.
Be careful.
Oh, maybe I can add it to the stream. Oh, cool. Now I know how to do it.
Wow.
This is a bull that I cut out of wood. It isn't completed. I added a head. I've been working on this thing for 3 months, Remington. We had a vote on the Storm Ventures group on naming this thing, and we ended up naming it after a contest was played. Non-recoverable. Very punny. It's fantastic. I painted it, and this is what it looks like now.
Nice. Look at that.
Yeah, he's a healthy boy. This bull is going to be on our booth over at Win the Storm. Remington and I are going to be there. It's a very professional booth.
Matt's projecting.
I showed this to my brother. He was like, that's gross.
It is gross.
Has anybody been to Panama City Beach and went to a steakhouse called Angelo's? This looks like that bull outside of Angelo's.
Does
but
it?
This one's better by 3. The multiplier by
Of 3?
Of 3.
Well, I don't get any hourly pay for this thing, and it was probably 72 hours of painting. That thing is 6 feet tall, by the way.
My gosh.
Yeah, it's a monster. It's a monster. Just
It's
apply that
got a
proportionally to the
monster.
other parts of it.
Looks great.
Thank you. Anyway, I had to share that. I hope you guys come and visit Non-Recoverable at Win the Storm. There's going to be some objects on the floor that you'll also have to dodge around. That usually comes from that end of the bull. It's a very professional booth.
I look forward to it.
Next week, we've got Jessica Stahl coming on.
Jessica Stahl with Ignite Results. Jessica is a doctor. She has more credentials than Dr. Phil by a lot. Because Dr. Phil's not a doctor at all. But he calls himself Dr. Phil, and Jessica Stahl doesn't even call herself Dr. Jess. So weird.
She's humble.
She is. I've been working with Jessica for a while. She's fairly new to the industry. Well, she's not new to the industry. She's been working with her father, who owns a roofing construction firm, and she has a doctorate in something that has to do with behavioral science or something along those lines that helps companies get better and builds their internal culture. That's the word I've been trying to think of. So she helps with culture and a lot of different aspects of it, but her
She's
doctor
gonna
gives
get
her a
you
lot of
some
insight.
culture.
Do what?
She's gonna get you some culture.
She's been trying to get me some
Yeah.
culture. I don't have any, so she's been failing miserably. Anyway, I haven't been able to actually work with her project yet, but I'm looking forward to it because we've been dodging each other based on this the time frame that we've had with the bill that passed, and we're not passed the bill that we've been dealing with in Georgia with Gabia. So hopefully I can get some time to actually start working with her in the very near future. I'm looking forward to it. But she's going to be on the show next Tuesday at 4 p.m. Eastern. She's a lot of fun. And I think we can ask her a whole bunch of different questions on what she would do in certain situations. I honestly plan to try to get everything out of her so I don't have to actually hire her myself. You think it'll work?
We'll see.
It's worth a shot.
We'll see. That's the
So,
goal.
Hopefully she doesn't watch the end of this show and she won't know what's coming. That'll be great. All right. So we'll see you guys next Tuesday at 4 p.m. Eastern time. We appreciate you joining us.
See you guys. Have
Take
a
care.
good one.